All right, I'm going to try to go live. It's being a little cranky with me.
You want to get started?
Special relationship.
All right, I was just letting you know that it was live. You can have whatever conversations you want.
I'd be on the right.
Okay. I'm going to call the meeting to order unless you think I should hold for any reason.
You should be good.
Okay. The time is 1:02. The chair calls to order the July 26th meeting of the Kansas Governmental Ethics Commission. Thank you, commissioners and staff, for your attendance. Before we approve the agenda and minutes from our prior meetings, I do see the first item is to just staff introductions. So Mark, do you want to speak to that point?
Yeah. Yeah, please. So we have a couple of staff to introduce. The first is Caitlin Bull-Stewart, who is our new general counsel here at the table with us and will be part of all of our meetings. Very lucky to have her. We also have Denise Davis, who is who's coming in now. She's our new PAC and Party coordinator. We're very lucky to have them join our team. So we're excited to work with them, and they've been great.
Welcome. Caitlin and Denise.
Aboard. Yeah.
Yeah, can I see you?
Welcome to both of you.
The owl, if you say something, the owl will find you.
Can you hear me?
Yep, there you are. All right.
It's nice to have you guys. Thank you.
Thank you.
Turning back to the agenda, we have, of course, the agenda, if everybody's had a chance to review it. And I see the minutes from our May 24th meeting. Can anyone identify any corrections that need to be made to either? If there are none, I will hear a motion to approve as written, both the agenda and minutes.
So moved.
Thank you, Jerry. Thank you, Jerry. The motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion to approve the agenda and minutes as written, signify by saying aye.
Aye.
All opposed, say nay. The motion passes. Turning to the agenda, we have an executive director's report.
Sure. So we've talked about the legislative changes a little bit, but there was some discussion that people wanted to hear the full blow-by-blow of what the ultimate legislative changes were to the Ethics Commission. So I put together just a quick once-over document that's kind of categorizes the changes and spells them out for everyone. If you have any questions, obviously let me know. All of these changes happened in House Sub for SB 208. We did have other legislative recommendations like we always do, and yet again, the legislature did not pass any of them. We frequently will get recommendations out of committee, but they often do not get heard on the floor. And the one time we did have one heard on the floor, the Senate did not take it up. So after the House voted for it. So this is all from House Sub for SB 208. The first and most of these changes, or many of these changes, are about hearing procedure. So the Administrative Procedure Act, CAPA, specifically applies, as well as civil procedure, to the Ethics Commission. Complaints must be filed within 5 years of violation. So we have an actual statute of limitations now. There's a new recusal regulation that we are working on researching now, and I anticipate having a draft to you in the coming months for approval. We're essentially going to pass a regulation that will require recusal in some instances, and we're modeling it off of what other ethics commissions do as well.
I'm sorry, what triggered that?
It was in the original bill, and ultimately there wasn't much opposition to having some sort of a recusal regulation, and there hasn't been much discussion over what will trigger that. But a lot of times it's financial conflicts, things like that, where that trigger those sorts of recusals. So that's where it came from. It was in the original bill, and it stayed throughout the process. In order to find probable cause on a complaint, it now will require 2/3 of the commissioners. Previously, it was a majority. Any respondent can now request the hearing be run by the Office of Administrative Hearings. After the hearing, OAH will make an initial determination. It'll be sent back to us. We can't hear new evidence, but the commission will make a final determination that likely will reflect the initial determination from OAH. Civil fines are now capped at triple the applicable fine for any one violation. So if someone hasn't had a previous violation and there are 100 counts that we have to resolve, the maximum fine we can assess is $15,000 in that instance. A district attorney or county prosecutor, assuming that the underlying violation is a crime, could choose to prosecute the underlying offense as the relevant misdemeanor and seek additional penalties beyond that. But our procedure is limited to 3 times what one violation would be. Alternatively, we did also add that it could also be double the pecuniary benefit. So if someone, this is something we did not have previously, where if someone has gained some sort of financial benefit from the underlying illegal conduct, then the fine can be 2 times or up to 2 times the pecuniary benefit. Civil fine payments are no longer go to the fee fund, they go to the state general fund. This is actually something that is going to be, it actually will give us budget stability because we changed PAC registrations to accommodate for this, and we'll talk about that momentarily. But any projected fine loss is actually something that is reflected in PAC registration changes. And last, on hearing procedure, the commission can't order community service or anything that's not otherwise required by the Campaign Finance Act, so other than training. So if the commission says that they'll be assessed $10,000 in an instance, but it would be reduced to $5,000 if they did certain conduct, all of that conduct has to be either training or something that is already required, like filing reports. I will note, it's not really about hearing procedure, it's a little CAPA related. One of the things that the commission will notice going forward is that when there are executive sessions to discuss complaints, frequently you will see a conflict counsel from the Attorney General's office serving in that role rather than any commission staff. And so essentially what will happen is we're working on a contract or an MOU with the Attorney General's office. They will come over for our meetings where we are hearing any sufficiency, probable cause, anything like that for a complaint. And executive session won't include myself or Caitlin. On page 2, there's campaign.
Wait a minute, I'm sorry, go back to that just a second.
Sure.
Say that just executive sessions won't. All right, sorry.
No, you're fine. You're fine. So here's what's going to happen. So when we have executive sessions that are discussing complaints, those executive sessions, typically complaints are filed by myself. The general counsel for the agency is serving in kind of a quasi role and often in some ways is representing myself. Because of that, it's best for us to have a conflict counsel from the Attorney General's office come over for those instances and essentially provide advice as an independent person. So it's no one who is connected in any way to the complainant, which would be me. So essentially what will happen is in those specific executive sessions, I won't be in there. Caitlin won't be in there. It'll be a conflict counsel from the Attorney General's office to ask any legal questions. And otherwise it would just be the commission. So we think this is probably the best approach going forward anyway, but I think that this will provide some clarity and guidance as well. That's probably the largest day-to-day change that you might notice because we frankly hear a lot of complaints. So you'll see that happen in our executive sessions for complaints. General campaign finance on page 2. We actually defined an agent. We went back and forth on this for a while and landed on something that I think is good. For the purpose of enforcing coordination and cooperation schemes, we now define what an agent is very specifically in statute. There was some discussion about right now in session, candidates for statewide and legislative office cannot solicit contributions from anyone who is other than a non-lobbyist individual. This sometimes created issues where people the biggest issue we ran into is that lobbyists would sign up for mailing lists, but they would do so on their personal account. So it was inadvertent violations that could occur in these instances. This bill allows those solicitations to occur without being a violation as long as they include a disclaimer saying this is not intended for lobbyists, and they still cannot accept contributions from those people as well. Campaign funds now have 3 additional items that they can be used, that campaign funds can be used for. These are all fairly close to something that was already permissible. Essentially paying volunteers or staff or providing rewards to those volunteers or staff as long as it somehow matches to a fair market value of those services. Paying civil fines or penalties assessed by the commission, which is normal as long as it's being assessed against that campaign. You can't pay it on behalf of someone else. You can't pay for someone else's campaign's penalties. and paying legal fees related to campaign finance investigations. On the bottom of page 2, you see the PAC registration changes. This is PAC registration changes or PAC registration levels had not changed in quite a while. This is the new way of for PACs to evaluate what level they should be registered at. So any PAC decides their registration level based on their anticipated future contributions. And if they end up being wrong, if they register at a lower amount and they end up taking in more than that, they have to then go back and pay and register at the higher amount. You'll see that for almost all PACs, they're almost all paying a higher amount. There's a small group of PACs that raised between $2,500 and $7,500 that pay $50 lower. But overall, this change actually accommodates and resolves the civil fines going to the state general fund. And this is a more stable source of revenue anyway. On page 3, obviously, we've talked quite a bit about the investigation changes. Now, in order to subpoena witnesses in a pre-complaint investigation or documents, in order to have the commission provide that subpoena, it used to require a 3/4 vote in physical presence. So everyone had to be here, and it had to require 75% of the commission physically present and voting for it. Now it only requires a 2/3 vote, and you can attend in any fashion, including on Teams, virtually, However, that subpoena has no force on its own. We have to go to district court to enforce it, and they can take however much time is necessary to issue an order to enforce it, which means our already glacial pace of investigations gets slowed down even more. The court shall issue the subpoena as long as it's sufficient, reasonable, and narrowly tailored, but anyone responding to a commission subpoena has a right to counsel, which is, in my view, patently ridiculous, but it's also something that ended up in the final bill. The commission cannot.
Question.
Yes.
Before you get to the next bullet point, but I have a couple questions about that last item. Is there going to be some kind of an appointment list available for counsel to be appointed, and also how is that funded, or is it going to be funded?
It's not funded from us, but there is no system set up that I'm aware of other than piggybacking on any current system. There's nothing in the bill that establishes any procedure for it. All that we know is that it's not coming out of our funds.
We're appointing, but they're being asked to appoint counsel and a non-criminal member.
Yes.
When did the Constitution change?
Well, many of the underlying violations are misdemeanors as probably the underlying justification. This is, again,
just an inquiry.
Yeah, I agree with you.
I get criticized enough if I fudge a little bit on the guideline for incomes to appoint counsel. I've been challenged on that, and it's like, folks, they can't afford counsel even if they make $1,000 more than what the grid says. I'll pick up criticism on that, and this is just a blatant open what? Okay.
Yes.
All right.
The last bullet on investigations is that we cannot provide legally binding immunity without similar immunity being provided by the DA or Attorney General. This is a little broader than current precedent in Kansas. I don't love that it's a little broader than that, but to the extent that it is consistent with previous jurisprudence, I'm fine with that. But last, under a couple little things under other, I guess they're not little, but they are things that don't really fit into another category. Anything we file in district court is now a claim pursuant to the anti-SLAPP statute, the PSPA. And we cannot require a respondent to waive rights in a dismissal, settlement, or otherwise. Are there any questions? If there are any questions, I can take those now. Otherwise, that's the end of the executive director's report.
Could I go back to the session where someone makes a request for the administrative body to hold the hearing above us, and it comes to us? What's the definitional parameter of what we can and cannot do? I mean, in other jurisdictions and areas, if I get something from a agency on the district board level, I have to make some specific findings. They either didn't follow the law or they can do the facts. What do we have here?
So in terms of something being sent over to the Office of Administrative Hearings,
Right.
that's something that any respondent can request.
I get
for
that.
any
I'm
item.
okay with
And
that. But when it comes back from them,
There,
we really don't, maybe I'm wrong, but we really don't have any review.
the
power
order,
at all.
the order can be modified.
On
The
what basis?
CAPA provides a basis for changing
Okay, so
initial
we'll have that
determinations.
statutory guideline.
Caitlin, do you happen to know offhand the underlying basis for changing an initial determination? I know that the commission can make
Okay.
certain alterations and we can get
You
the
don't need to
report.
check now, Kate. I just wanted to make sure we weren't in a free-for-all, that we did have some parameter, statutory or otherwise, regulatory wise, to tell us, we can apply this standard to that determination.
Right.
Otherwise, we have no authority at all.
Yes, it's my understanding those exist.
Okay,
So
all right.
Mark, I have some questions about under the campaign funds, under the campaign finance general classification. The first bullet, as far as being able to pay for those things, so long as they don't exceed fair market value. What's the standard or what would be required as far as evidence of fair market value? Is that something that they submit in the report, or is that something that the commission would then request once a report has been filed? What do we know about that process?
So fair market value actually is something that appears pretty frequently in the Campaign Finance Act in one way or another. If, for example, if someone is giving an in-kind contribution to a campaign, the initial valuation has to be reasonable and typically reflect fair market value. The giver values it for the campaign. If the campaign views it as an unreasonable valuation, they can revalue it. If we view it as not fair market value, we can come in and indicate that that needs to be revalued as well. So it's simply different things have different metrics. For example, I had a question the other day about what is the fair market value of selling a mailing list, for example. And there are metrics for these sorts of things. There are, for something like a mailing list, there are entire businesses that handle federal campaigns and federal PACs that operate that sort of selling and rental of mailing lists. So it really depends on the particular item. If it's like a laptop, the original purchase price, minus some depreciation. Fair market value is just a reasonable valuation based upon the market rate for that particular item. So as long as it is in line with that, that's consistent. Essentially, the fair market provision here just prevents a campaign from spending money for people who didn't do any work on a campaign, or from essentially stealing campaign dollars and giving them to a friend or family member.
Okay, thank you.
Any other questions? If there are none, we will go back to the agenda. Thank you, Mark. Going back, we have a civil penalty waiver discussion. With 3 bullets. Mark, do you want to take us through these, beginning with factors potentially justifying a waiver?
Sure, I'd be happy to lead the discussion a little bit. I think that we have a few questions to resolve. The commission has indicated in a few meetings now that you all are interested in having some more direct guidance and clear rules around what justifies and does not justify civil penalty waivers. So I think really what happens is we have 3 large questions and a couple of related questions that I think the commission should consider here. The first is, should the commission adopt an enumerated list of legitimate reasons that justify or allow consideration of a penalty waiver? There probably would be a unique circumstances catch-all, but it would spell out specific things that could potentially justify waiver, and maybe even could spell out reasons that are not bases for waiver, such as I didn't know about the filing deadline or I didn't pick up my mail. If the commission does adopt an enumerated list, what factors should appear on that list? The third is what proof should be required for a waiver? Should there be supporting documents submitted? An affidavit, should those be optional? A couple of related questions are, should there be a requirement that a waiver shouldn't be considered unless the report was filed within a certain time period after the underlying issue ended? In practice, this may be something that the commission resolves anyway without a formal regulatory note. And last, should we treat time-sensitive reports like primary and general campaign finance reports and in-session lobbyist reports differently than the other reports? For example, the January campaign finance report is typically, at least for civil penalty purposes, treated more generously than a primary or general election report when voters are looking for these reports. I will note as we go through these, I'm going to first talk through our penalty waivers in over a 4-year time period. But I want to also note that when we start looking at other states and what other people do, it's interesting to note that the focus of other states often is frankly, they're a lot more stringent than we are. They want to know what specific circumstances were out of your control that prevented filing of the report. There are issues like inactivity, the fact that they took corrective action, financial hardship. Those sorts of things are not generally considered because it didn't stop them from filing the report originally, at least in the states that we've looked at so far. So for us, in a 4-year time frame from 2019 to 2022, the commission considered 156 civil penalty waivers. Of those, the commission granted over half of them, 53%. 42 of them, so 27%, were given partial waivers, and about 20%, 31, were outright rejected. I went back and read all of them, which was a very fun time, going over 156 waivers that we've considered before, but it was really edifying. And in so doing, I've identified more or less 20 reasons that people isolate. Some of these are at times are subcategories of others. Sometimes they are asserting many different reasons. I think there's one waiver that asserted 7 or 8 reasons for a waiver that was predictably granted. So it really depends on, but to look at each one individually, we sometimes request administrative waivers, which usually means that the report was properly submitted, but for some reason our office wasn't apprised of that, and we request the waiver. There are sometimes that there's some other reason we request administrative waiver. I actually requested an administrative waiver at one point on behalf of a candidate who expressed a medical condition to me over the phone, and they just didn't submit a writing for it. Rather than continuing the assessment, I requested an admin waiver. The rest of these are ordered by how common they appear. So inactivity, where someone claims that they had no activity during the time period, which could mean, well, the transparency benefit for the public is limited, but sometimes they just believe that, well, I didn't do anything, so I don't have to file a report. So again, even within factors, there's quite a range. Of inactivity, the commission, you have the percentages there. The commission approved 45% of them and gave partial waivers to 34%. The next most common waiver, and one that we see appear in other states, well, is a medical or family issue preventing waiver. Historically, the commission grants these and does not typically ask for further proof. 80% have gotten granted, another 13% had partial waivers. Only 3 of 39 were denied in that time period. The next is mail, which that there was some issue with the mail. This really is a little bit out of whack from how you would normally expect it because COVID created a lot more waivers because of the massive delays of mail during that time frame. So just under half of them were granted, another quarter were given partial waivers. Whether something was someone else's responsibility was a tough category, and I couldn't find a way to make it more granular. Usually someone is asserting that someone else had the documents, they didn't have the records themselves. Someone else is explicitly taking responsibility, like a candidate saying it wasn't my treasurer's fault, it was mine. The commission has waived a little over half of them and given partial waivers to another 17%. Technology waivers are not uncommon. This is it appears in a few contexts, but the most common ones that we end up granting are often lobbyists who they completed their electronic report, but they did not hit the submit button at the end. And we are actually able, thanks to the Secretary of State system, we are able to work with them to confirm that, yes, the lobbyist actually did have all of it properly entered timely. They just didn't click the button, which means the commission has been a little generous in this category because that's pretty reasonable. I only am including the takes responsibility factor because the commission mentioned something about that a few meetings ago, that a few people think it's very important that someone take responsibility for the fact that the report was filed late. Of the reports, about 20 of them indicated that they were taking responsibility for it. And this doesn't on its own justify a waiver, but the commission did provide at least a partial waiver in 80% of these. So someone who is a first-time filer or otherwise has some lack of knowledge, usually because they aren't reading what we are sending them, is the commission has granted 7 of those 18 waivers and given another 7 a partial waiver. COVID is sometimes it's a medical subcategory, sometimes it's a male subcategory, but just splitting it out so that you can see the commission had quite a few COVID waiver requests and many of them were granted. On page 5, the transition of officers. Usually another treasurer has taken over for a previous treasurer or someone who did not properly resign.
Mark, you cut out there for a minute. Is it just me?
Gotten at least a partial waiver in this 4-year time frame. They have 14
Mark, you
waivers.
stilled on us. You froze.
Oh,
I think
no.
we missed about 30 seconds of what you said right there, Mark.
What was the last one you heard from me?
Um,
Can you hear me, Nick?
I can hear you now. Yeah.
Okay. What was the last category that we covered?
You were talking about COVID, I believe.
For first-time
Okay.
filers.
Okay, so COVID, the commission granted quite a few because COVID created some unique circumstances. Transition of officers, the commission granted 4 and gave partial waivers to 6. This is often a treasurer who, an appointment of treasurer form that wasn't filed when the officers change or any similar circumstance. When someone has a good filing history, they've been doing this for a while, the commission has always granted at least a partial waiver. The commission has always been understanding of that, at least in this time frame. And the commission is also pretty generously understanding of financial hardship, where if someone asserts that, then the commission will grant either a full or partial waiver in those instances. Failed to update contact information is really something that I don't think would on its own justify a waiver. When these are waived, it's because some other factor has also been present. But the commission has granted 6 waivers for when someone did not receive notice of certain issues because they didn't update their own contact info on the relevant form. Again, another one that probably does not on its own justify a waiver is travel, that they were gone and could not timely file. There were 11 of those and the commission granted 4. Ongoing issues with a person's bank, that can range pretty wildly depending on for culpability of the individual. That could be a previous treasurer not providing or not helping the bank transition. It could be that the individual at issue simply hasn't done the work to identify or to gain access to the bank account. Of 10 requests, 4 of them were waived and 2 of them were given partial waivers. This next one is one that, again, like failed to update contact information and travel on its own probably does not justify a waiver, where they lost the primary and despite being told otherwise thought they didn't need to file the general election report. The commission granted 4 of the 10 where that occurred and gave partial waivers to another 4. Typically other factors existed there. Sometimes people left employment. This is often a lobbyist category where someone left their employment, so they had no access to information to be able to file, and frequently they were not receiving the mail because they left employment, but they did not formally terminate as a lobbyist or they did not file their final report. The commission gave about half of these waivers and another 40% a partial waiver. Only 1 was denied. When a candidate only uses their personal funds, this is treated a little bit like inactivity, but this particular subclass of inactivity, the commission has given at least partial waivers in all 8 of those instances. Sometimes people assert that they were serving without compensation, that because they were in an unpaid position that justifies a waiver. The commission doesn't appear that has swayed them one way or the other. In these 6 instances, 1/3 has gotten a waiver, a 1/3 got a partial, and a 1/3 were denied. The last is that the individual or entity indicates that they have taken corrective action to prevent future violations from occurring. The commission has granted 50% of these 6, and another third were given partial waivers. Now, before we go on to some comparative examples of waivers in other jurisdictions, I wanted to pause for a minute to see if there are any questions about the waivers. That I know there's going to be quite a bit of discussion about this, but if anyone has any questions, that now would probably be a good time about the waivers that we have given.
I would like to think, given the window of your review, that we've become more consistent in the last couple of years. Would that be an accurate hope?
Yes, I would say so. I think part of this is that, frankly, there are unique factors that do sometimes justify a waiver, but even categorizing them, I think what we're seeing here is that within categories, culpability is something that changes pretty dramatically. At times, someone might be viewed as less culpable than someone else who might be viewed more culpable for the underlying non-filing or late filing of a particular issue. So the categories on their own are helpful, but they really only provide guidance. But yes, in general, I would say the commission is more, COVID, I think, threw a pretty big wrench in the works in terms of consistency within categories, just because there were many multi-factor waivers that came in around that time.
Any questions for Mark?
Okay. I would like to look at a couple other jurisdictions then, if there aren't any questions at this point. The first is Kansas Racing and Gaming Commission. Thanks to Josh and I for sending this over as an example. You'll see that the reg that they have spells out a few different things. Number 4 is a catch-all. Any justification or excuse for conduct can be used as a justification for a reduction. But you'll notice number 5 is essentially the same as our good history factor, and number 6 is the corrective action factor. It looks like here, just like what we've talked about is number 3, it's really, in many respects, it's about the culpability of the individual. But when we look at other ethics commissions or other ethics areas, we look first at the FEC. You can start really on the second page of the FEC's document there under submitting a challenge. It's probably predictable that because the federal government handles the most sophisticated candidates and candidacies, they have very, very few waiver requests that they find justified. I'll note that the first one is that it's based on factual errors, which essentially is our administrative waiver, that it wasn't actually filed late. Someone thought it was, and it wasn't. They also have the best efforts defense, which essentially is that there was no possible way they could have filed their report because of a natural disaster or some error in something provided by the FEC. They are not at all generous because they specifically identify that there are things that are not covered by the best efforts defense, including your own computer errors and issues. And what I think is particularly important here, even the unavailability of committee staff. So if a treasurer is hospitalized, the FEC would not consider that a justifiable waiver. I will note here that some of this is because, and some of the stringency is not only because of the sophistication of a campaign, but because the FEC's civil penalty system actually uses a formula that is not just based on how late it is, it's also how much money is in the campaign account and how long there's a lot of factors at play, including was it a election relevant report, things like that. But in general, not a lot of factors that apply for the FEC. California is another good example here. There's only a few factors that they consider. Unplanned medical issue, and they actually spell out who is considered who would justify a medical waiver and how close you had to be related to them for that. Also, unavailability of records. This comes up in a few other states as well, but I'll note that unavailability of records, they usually spell out that it's natural disaster related, some sort of fire, disaster, theft, some disaster of some kind occurred, preventing the records. But it can consider other areas as well. There are times where a previous treasurer, for example, may have not given records to the succeeding treasurer. You could view that as unavailability of records as well. I'll note here that California, and I'm going to talk about this here in a minute on Nebraska as well. If you look at the bottom under first-time filers there, someone who is a first-time filer and has never filed anything before can get a 50% waiver of their penalty in California, as long as they were not using a professional or experienced treasurer, which is very common in Kansas. Not a lot of campaigns use professional treasurers outside of some statewide campaigns. They have never filed a report before, and they had a low level of activity. So if they really weren't doing very much, they had a novice treasurer who had not done it before, and they've never filed a report before, they can get a 50% waiver in that instance. Not a full waiver, but 50%. California does have this unique circumstances rule, which shows up in all these jurisdictions we've looked at as well, that there might be something else they haven't considered that they might look at, but it's not a spelled out factor. So it's unlikely that it would have to be a pretty unique circumstance to justify the waiver. California spells out reasons that often cause rejection, including not receiving notice, a change of personnel. We talked about transition of officers, not picking up your mail, things like that that don't justify waiver. And we see those waivers all the time. Nebraska is the next state. Nebraska has a two-tier system, really essentially for evaluating waivers. The first part is a little bit like California's first-time filer waiver. If someone had no intent to file late, so they have to make some sort of showing that that was the case, they had not received a civil penalty in the last 2 years, or, for example, here was a first-time filer, and they raised and expended less than $5,000, then Nebraska can consider a full waiver or complete or a partial waiver. And that's part one for their waivers. Part two is essentially their for-cause waivers. They identify these. It's not a complete list, but it does include a number of factors here: medical, unavailability of records, unique factors. Those are the three we saw in California as well. If specifically Nebraska isolates that it has to, these issues that occurred that justify waiver have to have specifically occurred for the person required to file, someone who is essential to filing, or someone who's immediate family of one of those people. So they do say that they consider all of these independently based on the individual facts. But if you notice in that second to last paragraph in part two, they must provide documentation if they are submitting some sort of waiver request under part two. Kansas, we do not require documentation. I'm actually going to skip Texas for a minute. I'm going to come back, but the rest of these I'm including because the rest of these are discussions about what proof should be required for a waiver request. But I want to skip ahead to Michigan just for a second, just to show they are very similar to California, and they're very similar to California and Nebraska in terms of what reasons justify waiver. But I'll also note that on the back of the Michigan report, you'll see other considerations. Things that are specifically identified as not acceptable good cause include, but aren't limited to, not receiving notice, not being in town, not picking up mail, not being aware of the law, not sending a filing to the proper filing official, or attempting to file unsuccessfully. And we have given waivers for all of those factors in Kansas before. So again, another state that is much more stringent than we are. I'm going back to Texas now because the rest of these documents I'm including to discuss proof and what forms might be required. Texas, you'll see on the back of that page or the next page, you essentially fill out this form and you either get it notarized and it becomes an affidavit, or you can submit it as an unsworn declaration that you are signing. Either way, the commission can consider based on whether or not you have signed it as an affidavit or given it as an unsworn declaration. They can give it the requisite weight that they believe justifies it as well. In Iowa, they don't require notarization, doesn't require an affidavit, but at the bottom of the form, you do sign and say, I hereby attest to the accuracy and truthfulness of this information. But it's a pretty general form otherwise. But there is a formal form that people are submitting instead of just an email. In Michigan, it's a little complicated. They have to check all the right boxes. They have to indicate the reasons that they are basing it on, and they have to provide adequate documentation. And for each category, there is a spelled out discussion of what documentation justifies or would be used as support of each waiver request. So if you have unavailability of records, you should have a police fire insurance report containing the date of the occurrence or some other documentation. You have to submit documentation in Michigan. It's not an option. And you'll notice that form is obviously a bit more complicated than some of the others. California, it's not a formal affidavit, but you are signing under penalty of perjury, according to what it says at the bottom of the report. So it's again it's probably similar to an unsworn declaration, but you can put it. The form does have something that you are signing, attesting to its accuracy. So that goes to what proof should be required. There, I think, are a number of things that the commission could and should be talking about in terms of what direction to go on penalty waiver requests. But to provide consistency and to provide some sort of guidance, I think that following some of the guidance of some of these other states is probably a good idea, is to have some specific factors in play. That's just a quick overview. I can answer whatever questions people have, but otherwise you all have it.
I'll start. I loved all the detail and the information from the other states and entities. I really like the idea of a specific form. I liked Michigan's. I know you thought it was more complicated perhaps, but it gets to the nitty-gritty, and they've got to go through the hoops in order to request that waiver. So I'd like to see us move into something, I mean, maybe not exactly that, but some sort of form that actually has to be completed rather than just these rando emails and letters that we get trying to decipher what happened. But nice research. Thank you very much.
That's really
And
helpful.
I want to make a point that I particularly want to highlight Paige. She gave a lot of assistance in helping pull a lot of this together. So I appreciate that quite a bit.
Thank you, Paige.
Mark, did your review of all these states reveal any opportunities to just communicate better at the outset of these relationships, and particularly by casting a wide net, having a variety of channels? In looking at other states, do other states take the approach of mailing, emailing, perhaps even text messaging as a way of communicating? Anything affirmatively that they do just even before deadlines as just reminders that get sent out?
I don't know what steps they take. We actually have a lot of informal steps that we take here. There are quite a few bites at the apple that we provide to give reminders about those deadlines. Everyone who files gets an initial packet that includes those details of those deadlines. We often will call candidates, especially right after a report is due if that's missing. This is especially true in the lobbyist space. I know Jessica puts in a ton of work emailing and calling people who are outstanding. But yeah, there's a lot of work done on the ground to resolve problems before they occur. By the time a civil penalty has been assessed, there's usually been at least a few attempts to head it off before we get to that point. But they've definitely had notice. They know what the deadlines are, and they're provided to them.
Thanks.
I would say that a form similar to Michigan or one of those has to check the boxes would be very helpful for Paige going forward. We could track all of the issues, I mean, the reasons for the requests, as well as the disposition very, very easily. I like the idea of the form.
I wouldn't have to
guess
the category that these are falling in based on my reading.
Right. Yeah.
Yeah, it would give us context.
Form is a great idea.
Yeah, I mean, seeing these types of forms in the materials, I think would go a long way to contextualize and kind of remind us of our own kind of guiding principles about how we choose to view these.
So again, I think the broad questions are, should the commission adopt a list of things that could justify waiver? What factors should be on that list if that is adopted? What proof should be required? Those are the big three questions.
I'd like to see us tighten up the proof. In the past, we've relied upon any communication, oral or written, to staff to justify this illness, this whatever happened. And I certainly want to give everyone the benefit of the doubt of honesty, but the reality is we have no basis other than, hey, I was sick.
I come back to whether or not, I mean, if we think this is actually an important endeavor in the first place, then those fines and fees need to have a meaning behind them as well. And the deadlines need to have meanings too. So historically, my history is limited. So I'm not tied to any kind of prior voting or anything of that nature. And as I've been observing what's going on, it feels more like a personal preference and beauty pageant sort of approach as to whether something is waived, something is not, which provides no assistance to staff, no assistance to the people we're here to aid. So some guidance is necessary. Thinking in terms of importance, I really lean toward more of a federal approach of these are the things that simply will not be an excuse, which seems to be probably 60, 70% of what we've excused in the past. You know, realistically, a form would be great, self-attesting so that it is in fact under oath. And, you know, at least at that point in time, maybe people will take it seriously because it needs to either be a big deal or not.
I do want to respond real quick to something. I just bounce off of something you said. I agree with you. I think that having specific factors can help with that exact issue you're concerned about. But I also want to mention that in trying to get at the beauty pageant concern that I know has been mentioned before, one thing I did was I actually, in each of these 156 waivers, I checked the length of the waiver request. And the length of the waiver request did not actually have, I really thought it was not going to be this way, but the length of the waiver request actually did not end up having a substantial impact on the ultimate outcome, which actually was pretty surprising to me. I thought that a longer waiver request would be viewed more generously, and it's actually not the case. So I thought that was just an interesting side. I didn't end up including it in the materials because I didn't think that length of the waiver request was particularly helpful, but it was something that I did in part of the analysis.
If I may, I would add that having been among those present today, the one of the longest tenure on the commission, not John Solbach, of course, goes way back before that, but August 2011, I would make sure that everyone understands that the notion of a beauty pageant doesn't mean that there's been any favoritism. We're a nonpartisan, bipartisan. I mean, if someone walked in this room, I think that they sat and watched us, they would have no idea who appointed us. So everything has been impartial. We've tried to do our best and take it case by case and very carefully look at all the factors that you went through and Page tabulated. So we've been very careful, but I think at this point we would benefit from having a bit more systematic approach for those that we serve, as well as for those around the table.
My late arrival probably isn't allowing me to have the same kind of input that you all have, but it seems to me that, and maybe this is all due to age, but black and white is important to me. You know, guidance up front, making it, you know, as easy as possible for those to comply. Up front's important. Now, on the other side, after a violation, I think, you know, when it comes to penalty phase, you know, mitigating circumstances are certainly something we need to take into consideration. But I agree with what I'm hearing, I think, from everybody, and that is, you know, make it easy to understand, make it clear up front. You know, so it's not, you know, the same excuse of, geez, I didn't know type of thing. So I guess my 2 cents worth, that's kind of my input. And I would agree with the statement that this doesn't appear to me to be a committee that has a political agenda. I think everybody tries to be as fair as possible. And I think there's a lot of leniency when leniency is important.
So this is a strange comment, but as lawyers, sometimes the worst hope you have is the forlorn hope. And when we have qualifications that specifically say any possible reason or something that might work, what do you do? What do you do with that? It almost attracts more and more people and makes it so that they don't know what their outcome is, and no lawyer, no consultant can say you really don't have a chance. So I favor that clarity too.
I guess looking at the different examples, it's been quite helpful, and I certainly appreciate the research that has been done and the way the explanations have been given. I think a form could be worthwhile. What I'm concerned about is that we would become too rigid and maybe not as understanding of some particular circumstances. So I think there needs to be maybe a catch-all category, because certainly none of us would have anticipated the problems that came up during the COVID restrictions. So I think we need to keep some broad minds in place. And the other thing is, as practitioners, I think we're accustomed to seeing the phrase "for good cause." And, as many lawyers have experienced, we can be quite creative with what good cause can mean. I think also what needs to be focused on is the purpose of the statutes that we're overseeing, so that we keep those would be maybe the guardrails, so to speak, on what could be good cause and what could be eliminated as good cause maybe from the very beginning, such as I failed to read the statute or I failed to read the instructions on what was required of me when I decided to embark on this election endeavor. So those are my thoughts. I'm just fearful that we would be bound to something and get a little too rigid in our deliberations.
I would prefer that we definitely have the verification of their application, not just a signature. So we have some teeth in the process of, we can rely upon your statement because you said it was true, and we have an ability to enforce that. I'd also like to see a review of the exclusionary rules. There are some simple things that, no one can excuse that behavior on. Don't bother to file this if you meet one of these categories, because we're not going to consider it and we're not going to grant it. I do agree with Patty that in every human endeavor, we still have that element of there will be something that is beyond anyone's control. And this is either a fish or fowl. Are we equity or are we law? Are we in a domestic circumstance, or are we in a foreclosure where you have combinations of equity and law? Are we bound to be just legalistic in approach? I agree with Patty that we need to have some vamp, but I also agree with Chris that, the Hail Mary pass gets thrown a lot in the courtroom. It's like, well, Judge, for any other reason, you can do this. And then you start giving me all these reasons. And then on the record, what am I going to do on appeal? Not that I have to worry about what they do to me, because they'll reverse me anyway, but still, the reality is that just opens the door for me to be criticized again multiple times down the road. So I feel like there's a lot of positive came out of this particular endeavor, and thank you very much for all that hard work. But
yeah, well, Mark, is it fair to suggest that we could take a crack at putting together a form that would suit our needs based kind of on our discussion here today and based on what we're seeing in these examples, and come to the next meeting with a draft that we could discuss?
Sure. If I could maybe make a suggestion, I think that one of the things that would be very helpful, would be if, frankly, the commission had a discussion over what factors should be allowed or should generally just be considered as justifying a waiver. This also might be a good time before that discussion happens, if that is a discussion you want to have. This also might be a good time for the public comment, because I think that might also have some thoughts on what factors should apply, proof, things like that. I don't know what public comment may be out there, but that's, I think that's something that this may be a good time for that. I'm just making a suggestion.
No, I agree. Do we have anyone in the room?
We do. Kyle had something you
Yeah, I
want to
was
say.
going to say, at some point, this might be the appropriate subject matter for a select subcommittee to, I mean, you got to jazz it up with a good name.
General counsel should be
Exactly.
the catalyst to draft, and a subcommittee to put some parameters.
And then
to
for
the
public
framework.
comment.
Yeah, a subcommittee could definitely be an approach, for sure.
Sure.
Or
And by
Mr.
public
Nye may
comment
be
during that
willing to
process.
provide us some insight.
But yeah, I think Mr. Nye is in the room and what I think has public comment on this particular issue.
Great.
Yeah, really quick. Thank you for the opportunity for the public to.
If you want to come over to the table just to make sure the camera gets you.
Take my seat.
The owl camera is really nice, but it sometimes doesn't do great.
I ordered an owl camera first week. I dropped it and cracked it. So
Jeez.
county. So good job. Thank you for the opportunity to provide public comment. I know several meetings ago, that was one of the things that I had indicated that I thought might be helpful for you at least to hear in your deliberations when you are making policy, what the practitioner standpoint might look like. I have been the attorney on a few waiver requests, even one last meeting that was granted. I think this is a very good discussion, and I think it plays into the process that the legislature and Executive Director Skoglund and I engaged in last session to really come up with good bright line rules that my clients can follow. And I can advise them based on. I did send the Racing and Gaming reg, not because I think it's a model reg for ethics, but just because I think it shows that you don't always have to recreate the wheel, especially in the ethics standpoint as an administrative agency. And I think that patterning a lot of this off of first what other Kansas agencies have done, and then also what other ethics commissions have done is a great, you've got 90% of the way there, as well as your own history. The only reason I wanted to provide public comment along those lines is that this KSA 254152, I think is where we're in, and then the companion statute in chapter 46 for lobbyist reports is something that came up in the discussions during the session. Specifically after, I think your February meeting, you had someone that weighed in that said, it's all good and fine to have a waiver, but, I don't want to be stuck with the stigma of being an ethics violator. That's worth any $100, $500, $1,000 fine. And I would agree that in most 99% of these scenarios, it's a too bad, so sad type of situation. You've got a speeding ticket, you sped, pay the fine. It's not that big a deal. But there is a certain stigma that's attached to the idea of being a violator of an ethics statute versus a speeding statute. It gets reported in the media in a different way. And so I think that you should at least weigh in that in. What the question that came up at the time was, I think from one of the commissioners, was that does the commission even make a finding of fact that a violation has occurred? Because once you get to the waiver consideration, you're already a violator, and it's just a matter of whether we're going to give you clemency or not. And I think 99% of the time you're going to have a violation. There's no question. But one thing that did come up during the session in at least one of the drafts of the bills was whether 4152 should have a formal moment in time in which the commission ratifies or makes a finding of fact that a violation did occur before you go to the penalty phase with a waiver request. That would at least give some sort of review of an administrative decision that the executive director, the PAC coordinator makes.
Wait,
And I
let
think-
me interrupt for a second. Are you saying you're recommending that we find a violation before a waiver?
Yes. And I don't know if the statute necessarily allows that at this point. I think it's an administrative decision. But the best analogy, similar to what was previously discussed about the right to counsel in subpoena situations, that statute that's now in law was patterned exactly off of the Inquisition statute in Chapter 22, the criminal inquisition, where witnesses are afforded counsel if they're subject to an inquisition by a county or district attorney. So just like that, I don't think you necessarily have to recreate the wheel on this. The analogy that comes to mind is KSA 19-2962. I'm a county counselor, and so dealing with zoning appeals types issues, the Board of Zoning Appeals actually can hear and decide, now I'm quoting from B1 of that statute, hear and decide appeals where it is alleged that there's an error in any order, requirement, decision, or determination made by an administrative official in the enforcement of any regulations adopted pursuant to the zoning powers herein granted. I'm not saying there is going to be an error, because these are pretty straightforward, black and white, did you file it by the deadline type issues. But I did notice that at least in one of the waiver factors that Mark mentioned, one basis for a waiver, I don't know if at the FEC or somewhere else, was that there was an error in the administrative procedure part. So I think that actually would more properly be considered not in a clemency decision or a waiver decision, but whether there was a violation at all, because you are going to have, again, not much of a stigma, but it's still a stigma depending on who's getting reported on and what official is making the violation. It could be big news story that there was a violation and hamper future activities if you're an ethics violator. So all I would say is that just taking that into consideration, I don't know if you can do it via policy, rule, or reg. It may have to be touched up in the statute, and there may be reasons not to adopt something like that. But I at least wanted to mention that came up during the session. Anything you do here, I think you should mirror in Chapter 46. And that is one thing that I do know that at least I'll be recommending, and I'm sure Executive Director as well during the interim committees, is that whatever you do in Chapter 25, as far as due process, to the extent that you can and it makes sense, mirror it in 46 so that the practitioners have the same procedure regardless of the violation that's being alleged. Thank you for the opportunity.
If I actually could, if it's okay, I have a comment for that I think you might have some feedback on, if that's okay, Mr. Chairman.
Sure. Yeah, go ahead.
So do you think, I think the underlying concern you have about the finding a violation is that there are essentially, I want to make sure I'm clear, that you're concerned about circumstances where a civil penalty was assessed and ultimately, for whatever reason, in this rare instance, the actual person who was assessed should not have been assessed a penalty, or they were not the one who legally was responsible for the report.
Yeah,
essentially.
Again, it's a hypothetical. I just think that if there's a factual dispute regarding whether the report was filed, and staff has one interpretation and the filer has another interpretation, there should at least be the opportunity for an appeal that fact be adjudicated.
Could we streamline this and just simply say that in a waiver request, if in these, we can spell out what the circumstances would be that justifies it, the commission can essentially expunge a civil penalty?
The problem is if you never violated, there's nothing to expunge.
Sure.
So
I'm talking about just finding a way to walk it back without having to because I'm telling you, if we have to make formal findings of fact on every civil penalty, I mean, that's a slow process.
What I think would happen is you would just create a list like you have of civil penalties assessed. Mm-hmm. And I'm sure you got that data anyway in a spreadsheet. You just provide it as part of the materials. If there hasn't been a waiver request, then you just would proffer that these relate. There's nobody that's contesting it, and then the fact finding is made and the waiver or the penalty is assessed. And you catch it each meeting, basically. I am sympathetic to whether it creates an administrative burden. I just think that the due process aspect, there's really not an appeal of the fact that a violation occurred, which I would just want to reiterate. Sometimes that is a worse punishment than the fine itself, because you're now an ethics violator. And so Chapter 19, the zoning appeals came to mind as far as a way to appeal the fact that a violation occurred, not necessarily ask for a waiver.
Yeah, I'd be happy to look at that.
2 cents.
Well, thank you. Do the commissioners have any comments for Mark, or just in general about the issues raised by Mr. Nye?
I think Mr. Nye's point that I remember vividly that particular instance for that individual fits Patty's concern that we definitely need to keep maybe a forlorn opportunity or a catch-all opportunity, because my remembrance is it personally didn't seem right that that individual would be tagged with some type of a moniker on the record for the facts of that particular case. And as Mr. Nye indicates, at some point in the future, that person may aspire to some other area that this shadow could fall upon and be an undue burden or a distraction that may prevent them from being of great service to some other group or agency or the country.
Yeah, I agree. I mean, I too remember that and feeling that we didn't have really a tool available to us. I'm not sure that we do still, because that really sounds like more of a legislative act than an administrative act as far as removing what's been deemed by the legislature to be a violation.
I agree, Chris.
Any other thoughts? Well, what is our takeaway here? Do we want to form a subcommittee around trying to find some consensus around our path forward?
We could do that. We could form a subcommittee, or the commission could have some discussion on what factors are good to be should be considered in justifying a waiver, what factors should not be. That discussion can happen here, or the commission could just appoint a subcommittee. That would also work.
It maybe as a start for direction to say that there's a form, something which has some basis of oath to it, you know, self-attesting or whatnot, based off of items that are outside of that individual's control, but with some form of non-forlorn hope, but yet open category for the unforeseen.
I think that's fair. Anybody else? I would nominate Chris to chair that subcommittee. I like his thoughts and his legal analysis.
My connection's bad. What?
Good luck summarizing that in the minutes, Paige.
Well,
it was recorded.
This is out of my control.
You know, it's when we've done subcommittees in the past, it's often been kind of an opportunity to meet prior to that month's meeting, perhaps at the noon hour as opposed to the 1 hour. You know,
we lost you, Nick.
Have, let's say, a prior meeting of the subcommittee.
Mr. Chairman, I'm sorry, you froze for just a second there. What did you say?
Okay. If we want to meet, if we want to take this over the next 2, meetings, I mean, however we want to go about it, do we have any other commissioners that would like to be a part of the subcommittee?
I would, but I'm concerned that we maybe have a Zoom meeting and prior to that 1 hour thing. I'm out here till September, so.
Sure.
If I might mention, any subcommittee is likely to be virtual, and it probably won't just be before the next meeting, because I anticipate that I don't know how long this discussion will take, and I don't know if this will require multiple meetings of a subcommittee. Ultimately, that'd be up to the subcommittee. So.
Well, I think it would go a long way if the subcommittee could come up with a kind of a vivid picture of what the forum for us would look like, and then we can take comments from there.
It would be helpful to have a senior member like Kyle on the subcommittee too, I think.
So there we have it. Kyle, Jane, and Chris. Fair?
Not only is it cheaper for me to get into a movie now, but get on the subcommittee.
I didn't mean your age. I meant your tenure.
She walks it back.
Notice she didn't
Yeah,
say experience any.
that's true. That's true. Yeah.
The minutes will reflect, made a comment about age.
All
I
right.
made a comment before we started today that Abe Lincoln was in the law school class 2 ahead of me, so fair game.
Right,
Well,
that's subcommittee
Yeah, proof on the record.
operational, because I'll send an email out tomorrow about that, get that going.
sounds like it.
Great.
Great. Well, thank you guys for your work, staff for your work in putting this together, and commissioners for your willingness to continue to move the ball forward. Returning to the agenda, the next item we have is presiding officer selection discussion.
Yes.
And so I know that for the commissioner's sake, this is something that Executive Director Skoglund and Caitlin and John and I have already discussed. But yeah, Mark, if you want to provide kind of some background on just this issue.
Sure. So there's been some discussion that for a variety of reasons, including increasing the commission's comfort with procedural rules as well as some of the underlying substantive law, there are some people who have indicated they're interested in serving as hearing officer and essentially sharing the burden a little bit as well. So after some discussions, I put together a quick draft selection process just to see if there are thoughts on this. Essentially, the idea is that there's a pool of commissioners who could serve as hearing officer. I am often a complainant, so I won't know who is in the pool, and it's run entirely by the chair and vice chair. If anyone can volunteer to be in the pool, you just can't specifically request to be a hearing officer of a specific matter. Everyone is randomly drawn. If you were drawn for the last one, then you can't be drawn for the next one unless no one else is in the pool. If recusal has to happen, or if there's just not enough people to serve, the chair will serve. If the chair can't because of recusal, the vice chair will serve. If you both have to recuse, there's nothing in the policy for that, because I'm hoping that not possibly occur. If essentially there needs to be legal advice, then outside counsel, probably the conflict counsel from the AG's office, will provide assistance. If for some reason this policy creates a big difficulty in assigning a hearing officer in one matter because of something that's unanticipated, then the chair and vice chair can just agree on a hearing officer, but the complainant nor respondent gives input on the determination. The idea is that it's a process that includes some burden sharing without myself becoming part of it, because I'm often a complainant.
Any thoughts, questions, just about the proposal to share the workload among the commissioners? Caitlin, do you have any thoughts just about how you would recommend going about it? I mean, I kind of view this as an opportunity that makes sense, given that we have new requirements to conduct our hearings in a certain way. And so I kind of also view this as just a way to align an educational opportunity about how we want to be conducting these things on a going forward basis.
Yeah, I think the same as well. And as far as like statutorily or through the regs, this is all fine. We don't have a ton of restrictions on selecting the presiding or the hearing officer under either CAPA or any of our authorities. I generally think it's a good idea to rotate throughout, particularly just so everybody, those on the commission that don't have as much tenure have time, as well to get used to how things go on the ground, the substance of the complaint process. I think it would make everyone a bit more comfortable, and especially considering that we will be going to district court more now as well. So just being more pre-complaint stuff. So being more comfortable with the substance, I think, is just generally a good idea. I don't know, the best guidance on the random rolling of the boulder between hearing officers, but I think generally this is a great option.
Yeah. And Mark, would you anticipate that although we don't have any hearings on today's agenda, let's say, for instance, in our August meeting, would you anticipate us having hearings? Is that anything you have visibility to see now?
No, I wouldn't anticipate any hearings at that time. We're still trying to finalize our MOU with the AG's office to provide conflict counsel. Once that's resolved, then we have a backlog of complaints that we'll have to handle at that time.
Okay.
But yes. I do also want to note that the agenda does list public comment for this item as well. And I don't know what time you would want that. I don't know if there's public comment in the room.
Yeah, so now is certainly a great time. Does Mr. Nye wish to say anything?
He's saying no.
Okay. Any other questions before we move on?
If there's no questions or recommendations, this is something we could move forward with as a internal policy. We could memorialize in reg. There's a few options for sure, but either way, if you have feedback after the meeting that you think of, or if you have questions, obviously just let us know.
This is Patty, and I tried to get it before Mark started talking again, but I just wonder if maybe it should be available for everyone who is on the commission to serve as a hearing officer rather than having people opt in, so to speak. That this would be a role that any of us would play, and it would be up to the chair or vice chair to see that it's a equitable assignment, if you will, for those of us who are on the commission.
I'll admit the reason I made it a volunteer pool is because I didn't want to scare anyone off, but there's obviously lots of good reason to essentially allow anyone to serve as a hearing officer on a random draw or selection basis.
Following up with Patty, why don't we just use the alphabetical order? Everyone's eligible, but they can recuse and opt out.
Sure.
Yeah.
It just rotates.
Yeah.
Yeah.
If the commission wants everyone to be automatically in the pool, we can definitely do that.
Well,
have it rotate.
Right now, we are all attorneys or have been attorneys, fully licensed as practitioners. I'm not anymore. I'm fully retired. But I do know in the recent past, we've had people who have not been lawyers, and it's not a requirement to be a lawyer on it. But I think there could also be some, guidelines, so to speak, hearing officer guidelines, or how to handle a hearing guidelines that would be helpful.
Yeah. I like the idea of predictability too. So in terms of just like a rolling list, taking randomization out of the equation, I think would be my preference, but.
Yeah, everyone's eligible unless they determine not to serve. And it just rotates from the alphabet, and it continues to rotate through.
My goal is to eliminate any sort of predictability for me. I don't want it to be implied, for example, if I have 3 complaints to file, I don't want it to be implied that they were filed in a particular order to get particular hearing officers. Right. Yeah. I'm not going judge shopping here. I just want to make sure that
that's a legitimate concern. Everybody used to federally shop judges.
And they used to do district judges until we finally figured that out.
No comment.
So
you never did, Chris.
If the list were randomized, and then I think that's in some order, but it still goes through everyone. I think that solves a lot of that problem for sure.
Everyone's name's in the hopper. It gets pulled. If they choose not to serve, they can say no.
It gets re-randomized after everyone gets drawn.
Back in the bingo rule.
Yep.
Okay.
That works.
Well, if there's no public comment and if there are no further questions, we will move on with the agenda. We have 4 civil penalties to discuss on the record. Mark?
Yep, candidate and treasurer first. We've got 2 amended reports, both for Owen Donahoe at $10 each. We have a party in PACs. A treasurer for Invest in Kansas was 5 days late for $50 on an amended January report. We have a couple of lobbyist penalties. Carl McDonald for $1,000 and Daniel Shafton for $900. That's all the penalties for today.
All right, thank you, Mark. The next item on the agenda is civil penalty waiver requests, and we similarly have 4 to discuss.
It'll be interesting to do these after we've had this discussion on civil penalty factors. The first is Eugene Bradley. You have this individual was assessed $1,000. This is it's a lobbyist for the Enlisted Association of the Kansas National Guard. In terms of the categories we just talked about in the discussion, it's an unpaid position. He's a volunteer. He indicates it would be a significant financial burden. It's inactivity would apply because he did not expend any money in direct relation to lobbying. It's the first year they had a registered lobbyist, and he has deregistered. So there have been corrective action taken, and it's a first time. These are all factors that obviously the commission has historically looked at, and when considering a waiver. I will note, and the reason why I'm not going to have a recommendation here is because he had called the office on March 22nd and said he would file, and did not file until 13 days later on April 4th. And whenever that happens and someone indicates that they are aware of their late filing and then takes that long to file, I do not recommend a waiver. So I have no recommendation on this item instead of recommending a partial or complete waiver.
Was he given that factor, the timeline might factor into whether mercy was granted?
No.
Okay.
I'm sure not.
So the conversation was kind of like, get it in and you'll be okay.
The conversation is usually get it in, you have a civil penalty that is currently ticking, and if you get it in sooner, the penalty will be lower than it otherwise would be.
Okay.
Not because of a waiver, but because the penalty wouldn't have ticked to its maximum level. And it did end up ticking to the maximum for Eugene Bradley.
What is the civil penalty amount at issue?
1,000.
Do any commissioners wish to make a motion, or do any commissioners wish to use this opportunity to share some thoughts in the context of our prior discussion?
My initial thought, this is Mark Schoenifer, is volunteer, National Guard, and I'd like to see a lesser penalty. Certainly appears that he knew that he had a time deadline that was ticking and still didn't react promptly. So I would like to see a reduction of that fine, but I'd like to hear everybody's input on this. My initial thought is maybe 25% of what he's being assessed, but I'd like to hear everybody else's opinion.
Jerry, what do you think?
For being the conservative on the group, apparently, right, Jane? Or the bleeding heart, however it might be. I hear what you're saying, Mark, but the statement only of he's National Guard and a volunteer. I'm trying to balance that against the fact that he was clearly indicating he would file, and for reasons unknown to us, he did not file. I'm certainly not opposed to finding and a recommendation of some abatement of the overall. I guess I am a little shocked by it to be $1,000 for a volunteer in that regard.
Yeah.
So I would be opposed to that.
Jane, what do you think?
And I'm clear that they did file it. It was just late.
Yes.
Yes.
I'm thinking about the boxes that it checks, and I'm not the bleeding heart on the committee like Jerry, but I agree. This seems a little excessive for a volunteer.
Yeah. Chris?
Jake, Colorado's looking good on you.
Thank you very much.
So again, I just come back. I just go back to, this is an important thing or it's not an important thing. And we have these penalties put in place, these fines in place in numbers that the legislature has told us to follow. And being a National Guardsman, I'd hate to see him be, 16 degrees off on his artillery fire. So, sorry.
Patty?
Well, given the fact that the report did come in, and if it backs up what he's saying, that there was no activity, I think that we can allow for some part of a waiver. I'm also looking at the fact of he is a volunteer. I appreciate what Chris said with respect to his guard responsibilities, or what we would expect as a guardsperson to do. But I lean more towards the amount that Mark was looking at, that give him some time, that if he pays $250 within, I don't know what we've normally done, 30 days, then the rest will be abated.
Yeah. Kyle, thoughts?
Yeah, I almost have to recuse myself as prior service. But I understand the plight of enlisted soldiers, so I have a lot of empathy and sympathy with that. The fact that there was really no money involved in their treasury, that it was inactive, also goes into my consideration. And it doesn't sound like there's any money in their treasury to pay the fine, so it's really Eugene's money. And I would say $250, and I'd bump it down to maybe $160, taking into consideration 16 degrees of artillery mistake, if paid within a certain number of days. So I'd say $250, drop down to $160. And if he's ever asked why the $160, it can be explained to him.
I will maybe make a comment that we could obviously set it at some amount, but it feels a little arbitrary to set it at 160 based on the prior commentary. But yes, I understand the structure.
He was being facetious.
I just don't want to have to respond to an attorney who says that it's arbitrary.
Yeah, I'll say for myself that, yeah, I'm very sympathetic. He's got a lot of good factors, but the fact that there was the phone call indicating some awareness of the deadline, I think that certainly cuts the other direction. But this is a really good example of the difficulty around making some of these decisions, and because you're wanting to consider his personal situation. His service, you're wanting to consider just, speculating on the other obligations that he has going on in his life. And so, this is something for the subcommittee, I think, to use as an example, specifically as we look to build out a better structure. Considering everything, do any of the commissioners want to make a motion for a partial waiver?
I would go ahead and make that motion for the waiver of $250 to abate $750 of it to $250 if he's able to make payment, as Ms. Dingler was saying, within 30 days.
30 days. Do any commissioners wish to second that motion?
I'll second it.
Yeah. Thank you, Patty. Any additional discussion? Hearing none, all in favor of approving the motion to reduce to $250 if paid within 30 days, signify by saying aye.
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 All opposed, say nay. The motion passes. The next item is an Aaron Plaza.
Aaron Plaza is actually, it's going to be an odd administrative waiver. We've done, without going into all of the details of our discussions, it is the determination of Ethics Commission staff that Aaron Plaza was never actually the treasurer of the Kansas Society of Anesthesiologists PAC, and her name was filled out on a form, and she was assessed a penalty when she was not actually serving in that capacity. The reports were signed by someone else, communications were with someone else. It would be my recommendation to waive all of her penalty because she was never actually the treasurer. I didn't ask her to submit a writing because I didn't think one would be necessary.
Okay, thank you. I was looking at the documents for this.
This is if the commission does not grant a waiver, I would ask her to submit a writing, but I told her that I would submit it on her behalf as an administrative waiver.
So mirroring what
jurisdiction.
How do we waive something that we didn't have jurisdiction over in the first place?
That's what I'm saying.
She was,
I'm following.
She was appointed as the treasurer on an appointment of treasurer form. So she was the person who was legally liable for the filing of the form.
Did she fill it out?
It is, No, she did not complete the form. It was
So we
someone
can
else.
still, we can put your name on like every county treasurer?
So it is possible to, in these instances, it is possible to investigate the person who filled out the report as a possible fraudulent filing. In this particular instance, the person who completed the form already has over $2,000 in civil penalties. We didn't think it was necessary, and if it would be necessary, I wouldn't be able to confirm or deny whether or not we filed a complaint against that particular individual at this time.
Oh, Chris, I think it's lack of jurisdiction.
Yeah, agreed.
I'd say that I would actually move that we would dismiss this as a penalty, not a waiver of a penalty.
Right.
I would second it.
I would agree with that as well.
All right, the motion is to dismiss with respect to Ms. Aaron Plaza. It has been seconded. Is there any additional discussion or questions? Hearing none. Patty, did you have a question? No. Hearing none, all in favor of approving the motion to dismiss signify by saying aye.
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 All opposed say nay. The motion passes. The next item is a Tim Tarkelly.
Tim Tarkelly, because none of our waiver requests today are going to be easy. He has $900 in total assessments. His first assessment was in September 2020 for $300. He requested a penalty waiver, asserting most of the things that he has in this penalty waiver, though he has a lot more detail in this one than he did originally. The commission rejected his penalty waiver for that first $300 in October 2020. He was assessed another $300 in January 2021, another $300 in March 2021. He essentially was continuing as treasurer on the forms that were filed with our office. He never resigned with our office. In October 2020, his waiver request, which you don't have in front of you, you have his waiver request that he submitted for this meeting. He had indicated in October 2020 that he was considering resigning from this position today, and at least with respect to our office, never did so. In terms of the factors that apply here, however, he indicates that the organization was disorganized and never had access to the bank account, something we always warn treasurers about whenever we talk to them and they run into this issue. He indicates he quit the position, though if he did so internally and not with our office. He apparently still received our letters and ignored them. He notified the party and the clerk that he wasn't in that position, and they didn't do anything about it. We had sent letters in March 2021, May 2021, June 2021, and May 2023. He indicated that he hadn't heard anything about the initial appeal, which was rejected. We had sent, obviously, the normal things we do about rejections, plus the 4 letters that I just reminded you about. I'm understanding of his circumstance. I am a little upset that he didn't include some of these details in the original fine hearing back in October. Because there's already a dismissal of that first $300, I do not think that the first $300 in September 2020 is at issue. In my view, the only parts that are subject to this penalty waiver is the January 2021 and March 2021 assessments of $300 each. So $600 total, assuming you agree with that determination. And I have no recommendation because while I am understanding of the position he was in, legally he was the person who was responsible for those forms and apparently was not responding to our mail.
Thoughts, questions?
How much
Motion?
again?
In total, there's $900 in 3 assessments. The first $300 previously had a rejected penalty waiver. So I would say that based on that, there are $600 of penalties at issue.
Call back. I don't think we can reach back to the 300, but we do have 600.
It certainly bothers me when somebody doesn't respond despite your attempt to reach out to them. That's what troubles me.
I will say that our experience with this particular organization is that this issue is not unique to this individual. I think that this is a problem. I think it's an institutional problem. But again, I have a hard time with waivers like this. Again, factors only tell you so much. It's the word. There's a lot of detail that occurs.
Chris, this may fall into the category of we mean what we say and we say what we mean, and they just didn't listen. The rules have to have some meaning. Is that what you said before?
Yes, yes.
I'd have to agree with that.
And Mark, if I understand what you're saying, they were sending forms in during these time periods. Was he the one responsible for sending the forms in that indicated he was still the treasurer?
He was the treasurer on file at the time of all of these occurring. Those reports still to this day, is my understanding, have not been filed.
They
But
haven't.
he said he was going to resign and he didn't, right?
Correct. He claims he resigned, that he quit the position in his email. To my understanding, this means he quit internally and tried to have those communications, which I, again, am understanding of, but we have if you submit a writing to the commission in any way, an email, anything, saying that you have resigned as treasurer, then you resign. You free yourself up from that liability and those obligations at that time. But that didn't occur.
Jane, I'm going to accept your invitation to Colorado, but I'm going to move that we decline the request.
We typically don't have a motion to
That's
decline.
what
We just do not
don't move.
Right.
Mark, in a situation where somebody is claiming that they don't have access to banking information and then they have a deadline that hits, what would you prefer to see happen? That they file and then plan to amend later in order to meet the deadline?
In a worst case scenario, yes, but typically what happens in these instances is it's either one of two things has happened. Either a transition of officers occurred right before the deadline, and they did not, and the previous treasurer did not adequately provide the documentation to the bank to transition the officers, or they simply just waited until the deadline of the report before this became an issue. Their procrastination became everyone else's emergency. And in no way am I saying that that's what happened to Mr. Tarkelly. I'm just saying that bank issues are things that are not always, but usually something that is pretty easy to resolve. And they don't take a huge amount of time to do so. Sometimes they do, but not always. I'm understanding of these circumstances, and we frequently help people gain access to the bank accounts for organizations where they're a new treasurer.
Mm-hmm. Makes sense. Well, if there are no further questions, and if there are no motions, we will move on.
The next one is Robert Wood, the lobbyist for the Kansas Firearms Coalition. He was assessed $150 in May. We sent a failure to file on May 11th. We left a message with him on that same day and also emailed him that day. He filed on the 16th. So he was 2 days late after the grace period had run. He indicates in his communication that he was inactive. He had no expenditures during that time period. He also had some tech issues because his laptop apparently died with the information necessary to file. I have no recommendation on this particular item.
You say the fine's $250, right, Mark?
150.
150, okay.
Any questions? Do any commissioners wish to make a motion? If not, the next item on the agenda is executive session.
We have a 5-minute recess before we do executive session.
Sure.
Yay!
If someone could make that motion.
So moved.
Thanks.
Do I have a second?
Second.
Thank you, Jane. Any additional discussion on the motion to recess for 5 minutes?
No.
Hearing none, all in favor of approving the motion signify by saying aye.
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 All opposed say nay.
Butte.
Okay.
Our family's been coming out here for decades, and my husband and I
When they opened this resort.
pulled the plug and bought our own house out here, so.
Around, but the whole area was,
Yeah.
had ran a couple of horses and a couple of
Almost
shacks.
246.
And it was gorgeous place.
I just want to make sure we have a quorum before we do anything.
Yeah, I have 46 right now.
We've got 2 in the room, and you've got you 2, and there's
Yeah,
That was commendable.
he's here. He's ready to go. I just need to know his time.
10 minutes.
10 minutes.
Yeah.
10
Start,
minutes.
if we need more, you can come back.
Should we go straight up to three?
Caitlin, do you have folders for us?
Easy.
I'm sorry.
And you're freaking me out. I have still not learned how to do that. That's on
I
my
know.
bucket list. And I saw you doing it too.
Doing what?
Flipping the pen.
Flip the pen.
Oh, because I also was a debater.
I was a
Well,
debater for ethics too.
You never did the
We didn't have that
No,
prerequisite.
obviously, it wasn't a
We didn't
very
have
good
that
one.
prerequisite to be on the team. We didn't have to do that.
We can't.
No,
Yeah.
we didn't have
We need a
pens
motion.
then. Can you try flipping one of those feathers?
I think this is
with
going to
the
be,
ink in it?
we're going to have to amend our executive session agenda to include pen flipping.
Yes.
Um,
I don't even know how do you do it? I don't think that's
Amazing.
not the same way as I do it. I do it the easy way.
I just
Anyway,
want to, I just want
we
to.
will need the motion though.
All right, here we go. I move that the commission recess this open meeting to executive session with staff members Paige, Quintana Paget, Mark Skoglund, and Caitlin Bull Stewart present to discuss potential litigation with the attorney for the commission that would be privileged in the attorney-client relationship pursuant to KSA 75-4319, subparagraph B, subparagraph 2. The open meeting shall be resumed here at 3 p.m.
Second.
Thank you. Any additional discussion? Hearing none, all in favor of approving the motion to enter into an executive session signify by saying aye.
Aye.
All opposed, say nay.
Facebook feed, you would know that I posted something about, somebody had posted about, is that a skunk or is somebody smoking pot? And then the cartoon is a skunk smoking pot behind the fence that they're walking by. And it's like, my Facebook feed was, this is a regular conversation for us out here.
It's funny.
Mark, are we back on?
We are. Yep, we're good. So
All
I think we're
right.
good.
Well, returning to a regular session, the only item remaining is to simply point out that our next meeting is in 4 weeks on August 23rd. So we will plan on seeing everyone then. And I guess we'll leave it to the subcommittee to decide when they want to meet exactly. And we'll just wait to hear a report back from the subcommittee, I'm guessing at the next meeting. So are there any other items that commissioners wish to discuss before we adjourn?
Again, the next meeting date?
August 23rd.
Perfect.
You'll still be in Colorado.
Yes, I will.
All right. Well, if there are no other items to discuss, I will take a motion to adjourn.
So moved.
Thank you, Jerry. What was the second?
Second.
Jane, seconded. All right. Any additional discussion? Hearing none, all in favor of approving the motion to adjourn signify by saying aye.
Aye.
All opposed, say nay. The motion passes. Thanks, everyone, for your attendance today. We'll look forward to
Thank
seeing
y'all.
you at next month's meeting.
All right.
Thank you.
Have a great week, guys.
Very much.
Bye-bye.
Easy.
Good week.